the principles that we actually are.
Right.
So how can that be used against us? It is, because that's the Cloward and Piven strategy. I was talking to Gary Coates, who ran for school board in Delta and just lost by about, now there's a little bit of a dispute, but it appears about 85 votes. We're having the conversation, and this strategy that certain liberals have in this country is to attack the character, to attack, the means justifies the end. So instead of fair play and having integrity in a conversation and having a real conversation, they do character assassinations. Now those of us that are being more conservative or more conservative in our approach who value integrity, we believe in forgiveness. We believe in honor. We don't want to drag somebody's bad name, somebody's name to the mud. Let forgiveness take its course. That's part of what America is supposed to be about, integrity. We're supposed to have the attitude of, real champions. But, we've got a political strategy now when running for office to tear each other down. And this is how Gary lost the election, because he wouldn't resort to that kind of name calling. Barb?
When you say liberal, our minds go to a party, and a Democrat has been labeled as a liberal, and so when you talk conservative, we think of the Republican Party, and these are Republicans that did this to Gary Coates.
Okay, let's distinguish what liberal and conservative mean for the sake of my understanding, so you'll know where I'm coming from. I don't think liberals are evil people. As a matter of fact, there was a time when Christians were liberals. Bleeding heart liberals. I remember my dad saying that. They're people that cared about other people. But when you use a system of law to extort from one to give to somebody else, you're using the government in a way it was not intended to be used. If you want to be charitable or philanthropic, then pull the money out of your pocket and go give it. But when you use the instruments of government to that end, now you're setting up a system of welfare that will fall the nation, because it is a system of legal plunder, and we delved into that last time. So I don't find fault with liberals, except if they want to use the government to perfect their agenda. Now, on the other side, some who would consider themselves Democrats see conservatives as doing the same thing, using the government to foist an agenda of imposed morality. So both sides have this contention where, they're fighting for control of the government to prevent the other side from imposing their agenda on the other one. So now it's become a battle of philosophies, as a battle for the principles of freedom and what made America unique and special in the world. And I've always held the position that once somebody gets into office, they shouldn't be wearing a D or R on their chest. They should be championing the principles of America and lose the D or R thing and just come into an agreement with what the principles are. But it's become, the scary thing is the left sees the right as a bunch of fascists, the right sees the left as a bunch of commies. That was just a matter of whoever gets in control, they're fighting against the other side, setting up the regime, when the truth is the ultimate of that kind of outcome is totalitarianism.
Dave, wasn't the whole purpose of the Constitutional Convention to settle this argument? And then we agree?
I would say.
Now we're bringing it back up. We're trying to reinvent the country again.
The whole point of the federal Constitution. We're just talking federal, not state.
Right.
The whole point of the federal Constitution was to create a government with limited power, because the founding fathers just came out from underneath a despotism called King George, and they wanted to put latches on the ability of government to grow into a dictatorship. So they delegated certain powers, and as long as the federal government is operating within those delegated powers, they're operating within their jurisdiction. And there's not a whole lot of powers that the federal government was granted. So as long as they're operating within those confines, they're operating within that jurisdiction called the United States. So yes, the whole point of the Constitution was to limit the power of a federal government, to prevent it from becoming a dictator, to prevent it from becoming a monarch, to prevent it from centralizing all power in itself. And I'm going to get into a little bit of that here in a minute. Okay, so again, going back to jurisdiction, jurisdiction is a very fundamental principle. So it's one we can all get our minds around. Fundamental principles in law are known as maxims. Okay, an established principle or proposition, a principle of law universally admitted as being just and consonant with reason. All law is supposed to be reasonable and just. If it's not reasonable, it's unreasonable. And if we start building laws and systems around unreasonableness, it just increases in its unreasonableness, trying to stabilize the previous unreasonableness. Maxims of law are what America's jurisprudence was originally founded in. And this is what the Founding Fathers followed. These were tried and tested principles. Maxims in law are somewhat like axioms in geometry. They are principles and authorities and part of the general customs or common law of the land, and are of the same strength as acts of parliament when the judges have determined what is a maxim which belongs to the judges and not to the jury. Maxims of law are holden for law, and in other cases they may be applied to them, shall be taken for granted. A maxim is like 1 and 1 is 2. We assume for the sake of this geometric equation that 1 and 1 is 2. And so everybody agrees that the tape measure has 12 inches to build a house. These are principles that we all accept in order to, this is the color, turquoise. This is the color burgundy. There are some things that we have to accept as fundamental truths. Those are what maxims are. The application of the maxim to the case before the court is generally the only difficulty. The true method of making the application is to ascertain how the maxim arose and to consider whether the case to which it is applied is of the same character or whether it is an exception to an apparently general rule. That might just sound like a bunch of words right now. Maybe this will help. The following are some of the more important maxims. The alterations of any of the maxims of the common law are dangerous. That's a maxim. In other words, we're going to start out with what's reasonable. That's a reasonable statement. If you're going to mess with the principles, that's a dangerous thing to do because you're messing with the foundation. Here's a couple more. By the way, maxims you'll find on the internet. Look for Bovier's Law Dictionary and just look up maxims. There's hundreds of them. No one is bound to do what is impossible. Now, that's simple, right? This is a maxim. From the words of law, there must be no departure. He ought not to be heard who advances a proposition contrary to the rules of law. When the plaintiff does not prove his case, the defendant is absolved. The burden of proof is on the plaintiff. If the plaintiff is going to bring a charge, they have to prove their case. This is where the maxim of innocent until proven guilty comes from. An act done by me against my will is not my act. A man convinced against his will is of the same opinion still. Right? So this is a fundamental maxim. Are these unreasonable? Every maxim has a reasonable root to it. An act does not make a person guilty unless the intention be guilty. The maxim applies only to criminal cases. In civil matters it is otherwise. Time runs against the slothful and those who neglect their rights. A delegated authority cannot be again delegated. Now that's an interesting one because I think a lot of the problems that we're experiencing in America is because Congress has redelegated powers that were reserved specifically to it, specifically like the Federal Reserve System. When the New Deal came along, Roosevelt created a lot of administrative agencies. Well, no, Congress created administrative agencies and empowered them, and several of these administrative agencies were challenged as being unconstitutional, and the courts agreed. But it didn't stop. We didn't go far enough. The Federal Reserve System has never been challenged as an unlawful delegation of legislative authority. But this is a maxim that it would be founded on. The power which is derived cannot be greater than that which it is derived. And we talked about that last week. If I as an individual don't have the power to steal from Tony, then the government doesn't have the power to steal from Tony. You know, if we as a group don't have the power to steal from Tony, then the government can't have that power. It's just, you know, this is the scope and the limitations according to the maxims of law of the power of government. The appointment or designation of one is the exclusion of another. And that expressed makes that which is implied cease. So if I designate Tony as my power of attorney, none of the rest of you can have it. That expressed is that, and that expressed makes that which is implied cease. If there's a statute that makes something specifically the way it is, then any implication or inference that something may have come from somewhere else ceases. The written law becomes the law. And this is where the common law ends up getting edged aside. But it doesn't change the maxim, because the maxim is what you measure the statute by. How do you know if a statute is unconstitutional? You got to measure it against something. And you typically use maxims of law to measure the validity of statutes. Every man's house is his castle. There's a maxim. Everybody knows that one. Two cannot possess one thing each in entirety. Now, I talked a little bit earlier about the different jurisdictions that the Eisenhower report came up with, and one of those jurisdictions is called concurrent jurisdiction. Concurrent jurisdiction is where the federal government and the state government share jurisdiction over the same property.
Shouldn't be that way.
Is that possible? Not according to the maxims of law. But our legal schools and our legal scholars in this country are not making this distinction. Again, they're collapsing the entire United States system into one big happy family. And as a result of that, the federal government looks like it is supreme, while the states are merely political subdivisions of that one supreme. And if we keep going down this road, the United Nations will become the one supreme, with the United States being merely a political subdivision of that, and the state of Colorado being reduced to mere municipality that is subject to all of the laws up and downstream. Two cannot possess one thing each in its entirety. I wanted to put a lot of emphasis on that. Okay, this was in the newspaper. There was a group of guys that went and reopened a road near Olathe. Now, this was a very audacious act. And I was involved, and I'm not afraid to stand up and tell you why. This road, Cushman Creek Road, is a county road in Montrose County. The BLM put a barricade across this road. This road had never been closed. The BLM wants to argue that the road was theirs and they had the right to put this barricade on this road. Those of us that went up there believed otherwise, to the point where we tore that barricade out of there. Now, the reason that we did this was to make a statement. When a government becomes destructive to the end it was established to secure, the people have the right to alter or abolish it. Now, nowhere in there does it say how. Okay? When did the Founding Fathers abolish the King of Great Britain? When the final shot was fired? They threw that government off when they signed the Declaration of Independence. All right? The act of throwing off the government doesn't happen when the guns start firing to defend a position. The act of throwing off the government has to happen in the mind first. It has to recognize that the principles of law have been violated. And then the conversations have to be had to decide how to go about doing this. In this country, that kind of speech is protected because the people have a right to alter or abolish government. Now, a lot of people were upset with those of us that went up here and did this because we didn't go ask for permission. If we'd asked for permission, they would have said no. And I told that to one of the county commissioners there in Montrose. Why didn't you come and talk to us about it first? I said, you might have said no. And he just smiled. We're not asking for permission because the Montrose County Commissioners have been negligent in the performance of their duty. This road is a county road and the federal government occupied it with an illegal barricade. It was never closed. It is a usurpation of federal jurisdiction. Yes, sir.
And the BLM didn't ask the county for permission.
BLM did not have, well, okay. This is where the conversation's going to get good. They have a travel management plan. And in the travel management plan, the people who were given an opportunity to put their comments in, and so a judgment was made to close that road according to the travel management plan. All right, so where's the jurisdiction? The question is jurisdiction. Is this an illegal act? Robert Shalakas and Mr. Moe, what was his name?
Ted Moe.
Ted Moe believed they are, they're Department of the Interior agents working for the BLM. And I got a phone call. David, we need to talk to you about Cushman Creek Road. So I grabbed a paralegal friend of mine and we went 2-on-1, 2-on-2. I didn't want to be outnumbered. And we had a conversation about jurisdiction. And so the conversation never got to the merits or the facts of the case. I wouldn't discuss with him anything about what happened up there. The only conversation I was having with him was one of jurisdiction. And so the whole 45 minutes of conversation was about, what are you doing talking to me when whatever happened up there happened on a county road? He says, well, that was federal property that was destroyed up there. Well, wait a minute, that's a county road. Now, if a private individual puts a barricade up on a county road, that's illegal. How is it any less legal if the government does it? It's not. This statute is written within Colorado. It governs according to the legislative jurisdiction of the General Assembly. This is the law of the state, and according to this, whoever intentionally blocks, obstructs, or closes any public highway is described in this section that extends to any public land, including public land belonging to the federal government. They wanted to claim, well, that's BLM land. Well, that land doesn't belong to the federal government, because according to this, they only have a proprietary interest in that land. They don't have legislative jurisdiction. They have a proprietary interest. They don't have concurrent jurisdiction. They have a proprietary interest. The BLM is proprietors on the land. Oh, by the way, it has nothing to do with the roads. The roads and the lands are distinguished from each other. Roads are not land. Roads are right-of-ways, and they fall under a whole different aspect of law than lands do. So the BLM is a proprietor over the lands, but they had no interest in the road. The roads belong to the county. There is a specific means by which the county has to follow, according to Colorado law, to either vacate or abandon a road. So until such time happens, that road is still subject to the control and regulation of the county commissioners. That is within their jurisdiction. The BLM is upset because in the process of taking out their obstruction, it got broke.
David?
Yes, sir?
That's backed up by the commissioner, the Montrose commissioner's ordinance that honors that sovereignty of the county. All roads are presumed to be county roads. What about in a county like Mesa County where we don't have